Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, as the title suggests, we're going to be discussing travel issues with respect to green card holders, also known as lawful permanent residents in the United States. What are we talking about here? Well, you'll see it rather frequently. I see it in Thailand in the context of you'll often see, a couple will have met while an American will be in Thailand for maybe not necessarily a short-term business assignment, but a contract that might last 3 to 5 years. And they meet their Thai spouse, they get married, and they go ahead and apply for immigration benefits back to the United States. In that event, the Thai spouse will go ahead and presumably come back in either on a fiancé or a marriage visa. They're going to get a green card. They're going to be able to live in the United States pretty much without interruption thereafter. Where you get into issues with respect to this, though, is, and I've often seen it in the context, again, of expats here in Thailand. They've been working here, they met here, they go back to the United States, and then say 10 years later, the American citizen who came here in the first place decides to retire. And he or she wants to come back to Thailand to live on a more full-time basis. Well, the requirement is that the lawful permanent resident needs to maintain their residence in the United States. And being outside of the United States for too long a period of time can result in a presumption of abandonment of residence. Now, what is too long a period of time? Well, it's very hard to gauge that. There is no bright line rule where 49 days is perfect and 50 days is too much or something like this. There is no number, okay? Generally speaking, U.S. Customs and Border Protection, as well as immigration judges and immigration authorities, will often look at sort of the totality of a given immigrant's travel circumstances. If they frequently leave the country for a month or 2 months at a time, but then return, I don't think you're going to be looking at a big issue with that. But if they're spending, out of a given 3 years, they're spending 2.5 abroad, that can be problematic. In fact, that can be really problematic. That could lead to a presumption of abandonment of residence. It may even lead to a situation where one has to seek what's called an SB1 returning resident visa. We have another video on this channel which specifically discusses the SB1 returning resident visa. But one major tip, and something that I think is of much interest and would be very beneficial to those who think that they're going to spend a substantial time outside the United States, at least at one given stretch, is application for a reentry permit. A lawful permanent resident in the United States can go ahead and apply for a reentry permit. And a reentry permit is granted with a 2-year validity. And so long as that individual returns under the expiration date of the reentry permit itself, so within 2 years of leaving the United States, that individual is still going to remain in status and the presumption of abandonment is not going to be raised. Another thing to think about, it's a slightly different way of looking at it, but naturalization to U.S. citizenship. If a Thai national, for example, or any foreign national who has lawful permanent residence, but may be wanting to go abroad, but return to the United States either periodically or regularly, but they just don't know exactly when they would be doing that. If they qualify for naturalization, naturalization is a good way to deal with that. Naturalizing to U.S. citizen results in getting rid of one's green card, and now that individual has a U.S. passport. If that individual wants to spend the rest of their life abroad, there's nothing particularly wrong with that. Or if they want to spend, 364 days a year abroad and come back for 1 day, great, no problem. In the past, there was this sort of conventional wisdom of as long as you set foot on U.S. soil once every year, that was enough to maintain your residence. Again, there is no bright line rule with respect to this stuff, but that is not a good rule of thumb to sort of operate under. They, generally speaking, U.S. Customs and Border Protection, and they will take people to secondary inspection and request information about their travel history. They can cause a lot of hassle, for lack of a better term, for those who are traveling abroad and spending a significant amount of time while in lawful permanent resident status, but they're spending a significant amount of time abroad. Again, naturalization would cure this. A reentry permit would remedy this, at least temporarily. But these are considerations that have to be taken under advisement for those who are going to be traveling significantly outside the United States. Finally, and we've done a specific video on this channel, There is also the possibility of doing what's called an I-407 surrender, and then by surrendering one's green card, one can turn around and apply for a tourist visa. Again, one's circumstances is going to be, one needs to analyze one's circumstances with respect to doing that, and I really recommend checking out the other video on this channel specific to that. But the thing to take away from this video, that I would like taken away from this video specifically on I-407 surrenders, is one really needs to analyze their immigration status and everything before surrendering a green card. It is a major decision. You're giving up substantial rights and benefits, and doing so should not be undertaken lightly. But that being said, it is an option, and there are those who simply don't wish to reside in the U.S. any longer, and they do an I-407 surrender, and they use a tourist visa to periodically travel back to the United States when and if it suits them.